Welcome to our International Dispute Series by Taylor Wessing. Today, we will look at a key development at the intersection of EU law, EU sanctions, and arbitration, the Advocate General Biondi's opinion regarding the Rebel case. This opinion deals with the question whether, and if so, how far, disputes over claims that are affected by EU sanctions are arbitrable or not. I am Laure Ude-la-Colombe from Taylor Wessing Paris, and together with my colleagues Ivo Deskovic from Austria and Donata von Ensberg from Germany, we will consider what this opinion means in practice for arbitration going forward.
The short answer is, according to Advocate General Biondi, yes, but with limits. He confirms that claims in matters where EU sanctions provide limits or constraints for payments remain arbitrable as such. This means that arbitration agreements are not invalid just because sanctions are involved in a dispute. This aligns with the general pro-arbitration stance in EU law.
However, the key distinction is between access to arbitration and what arbitrators can actually decide. Even if a party can submit their dispute to arbitration, the arbitral tribunal must fully respect EU law, which includes sanctions. In other words, where EU sanctions prohibit fulfillment of a contract, the tribunal cannot award a claim to the sanctioned party.
The case was the following. Rebel, a Swedish company, could not export goods to a Russian company because of EU sanctions, even though the Russian company had already paid an advance. The Swedish tribunal, which originally decided the case, ordered Rebel to repay that advance with interest, but it rejected the Russian company's additional claim for damages, which was based on the non-performance of the contract.
The European Court of Justice now is asked to decide whether such a claim by a Russian party for repayment of advance or for damages or for interest must not be satisfied because they fall under the so-called no claims clause included in EU regulations. Secondly, and more fundamentally, it must also clarify whether disputes about such sanction-related matters are arbitrable at all.
As already highlighted, the answer to the second question is a yes. The claims are arbitrable, but tribunals must apply the following principles.
Advocate General Biondi follows the Swedish tribunal and agrees that the damages claim seeking an additional financial advantage from the prohibited transaction are caught by the no claims clause and therefore cannot be satisfied.
But his opinion differs when it comes to the repayment of the advance and interest. The Swedish tribunal granted this claim, arguing that it only restores the status quo ante and is therefore not a prohibited claim under Article 11, Regulation 833/2014, so it could be granted. Advocate General Biondi, in contrast, considers that repayment of the advance and the accessory interest also fall within the scope of Article 11, and thus must in general also not be satisfied as they are directly connected to the sanctioned transaction.
Yes, but that creates a real tension. On the one hand, the rationale is compelling that the seller should not be enriched by being allowed to keep the advance payment, although it never had to fulfill its part of the contract, meaning it never had to deliver the goods sold. On the other hand, the purpose of sanctions is to ensure that no payments are made to sanctioned parties.
In order to resolve this tension, Advocate General Biondi clarifies that the claim can be granted, but, and that is the decisive part of his opinion, but either the enforcement of the award should be suspended or a declaratory award protecting that claim should be issued. Since the sanctions are intended to apply only for a limited period of time and can be lifted again, payment of the amount claimed should only be done after the sanctions and the no claims rule are no longer in force.
This leaves open a very practical question. How can prayers for relief be worded in a way that reflects this? In general, awards must be automatically enforceable and are therefore adverse to any kind of conditions, including a condition that it only becomes enforceable if and when sanctions are lifted. With many sanction-related cases being arbitrated at the current time, we can expect that tribunals and courts will resolve this issue in the not-too-distant future.
It also means that arbitration remains available, but EU sanctions law fundamentally shapes both what tribunals can award and what courts will enforce. Hence, courts are empowered to closely examine arbitral awards that concern facts linked to sanction and to set them aside if EU sanctions law has not been fully complied with.